Judge, I believe you might be muted.
Okay, there. Excuse me, so I'm the one that was muted. Thank you. Mr. Zaghari, are you ready to argue?
I'm indeed, my lord.
Can we just make sure that everybody is with us at this stage? Mr. Allen, is he there? Mr. Titus, sorry, excuse me. Is you there? All right. So you'll be next in line, Mr. Titus.
I'm ready, waiting
because, you're ready. You're in the starting blocks. You're waiting for the pistol. All right.
Waiting.
And you must just remember, Mr. Zaghari has drafted 70 pages of heads of argument and another 10 pages. So that is 80 pages. If I allow him to carry on reading that, we're going to sit here until tomorrow morning.
We're going to need that extra day, definitely.
Okay. All right, but let us hear what Mr. Zaghari says. Mr. Zaghari, as I indicated, you are please, you don't have to read each and everything. And also, I've also received your 10 further pages last week. Can I just ask you before you start, the authority, it puzzles me a bit. I was involved in another matter where it was a trial action, but it didn't go on because there was application for postponement.
Yes.
But there was also by the defendants a counter or a conditional counter claim.
Yes.
And I was just wondering at that stage, and I didn't do any research because the matter didn't carry on. But can this tribunal deal with the conditional counterclaim? You know, in Letla, the Constitutional Court has now said, well, you may go and do legality reviews.
Yes.
But the tribunal is a creature of statute. Have you got authority that, you know, that we can actually make orders as you request there in your notice, in your counter application?
My lord, I can answer you on two bases. The first being, if one, to the extent that there is no express provision or rule which assists this tribunal to regulate its own procedures, then one can have a look at what Rule 28 of the tribunal's rules say, is that the court can adopt any proceedings or procedures which assist it in order to conduct its own procedures. Because the counterclaim or the conditional counterclaim is interlinked. It flows from the application for a review in relation to the alleged impugned decision to award a contract to the first and the second respondent. So those two things are interlinked with each other. So to that extent, one cannot literally launch a separate application or a separate procedure when the facts in relation to both are the same and similar, and the courts are clear. It's also, you could have a consolidation, if you will, where the court deals with the same or similar issues, the same and similar parties, where the court then have that benefit, and in light of that can make a finding. If I'm not mistaken, Rule 10 of the Uniform Rules make provision for consolidation. And now that the parties are in front of you, this tribunal may, in light of Rule 28, then adopt such procedure which enable it to regulate its own procedure. So to answer your question, yes, and that might be the authority to allow this tribunal to proceed on the basis, if it find, which it must, that there is no basis for the setting aside of the contract to deliver the PPE, that it in that regard will either have to reject or dismiss the application. But to the extent that it find that there is some grounds which we deny, then in those circumstances we say that we are entitled to a counter claim, and it's made clear. And I don't understand the applicant's argument in this regard, because even if you have briefly, even if you have regard to what is stated in All Pay 2, the Constitutional Court and together with the Black Says matter, the Constitutional Court there, they dealt with unlawful or illegal contracts. The Constitutional Court did not say that the party was not entitled to retain their agreement. In fact, the matter was postponed to allow the contract to run its course. That in itself show clearly that even in those circumstances where you have a unlawful agreement and that party wasn't able to reap the benefits in terms or which arise from the agreement. What we have in front of you, my lord, is an agreement where you have an innocent party and the party has concluded and delivered. So if you have delivered the goods which was purchased from you, then surely if they now ask and say that the agreement must be set aside, then you're entitled for restitution. And that means, in essence, is either the second applicant must return all the PPE to the extent that it's possible. If not, it must return the monetary value of what was given to it.
Yeah, no, I follow that. You know, that would be the case in a high court scenario.
Yes.
You know, at this stage, we're sitting with the tribunal,
yes,
who is a creature of statute, and we may not have that right to do that. You know, what could have happened is you know, for the so-called innocent party to say, well, listen, I'm going to institute action in the High Court, and I'm going to because on the basis. Well, it may also be difficult, or you could have, for example, I'm just trying to think about this. You can't institute the action in the High Court because you say the contract is legal, but you could have said, well, I ask that these proceedings are being stopped, and so that allow us to go to the High Court. But maybe I'm just unnecessary. You know, I'm just considering this issue. Yes. I don't want to make, if I'm in your favor, eventually to make an order which I could not have made. I can understand. I can understand in a legality review, as you say, is it's a court may, for example, say, well, the contract was illegal, for example, but it's been completed, payment has been made, delivery has taken place. I'm not going to make any further orders.
Yes. Can we adopt, with reference to what my lord have said earlier? My lord was said that my lord would follow the practical or pragmatic approach.
Yeah.
We submit.
I'll do that. Yes.
Yeah, we submit the following in light of that, or in the context of that. We submit the following. We say that if, as in this case, the SIU can sue out of, whether it's by way of a review on the basis of legality, sue out of the tribunal, which it was legally created for that particular purpose. And now you have legal consequences which flow out of that particular institution of legal processes. We say we similarly can either piggyback on that, in the sense that we say, well, if you can sue out of the tribunal, we can similarly ask for the tribunal to then come to us and say, well, come to our aid. To the extent that you find in their favor, we say we have a counterclaim. The difficulty, of course, which we have if we stop the proceedings in the SIU, is that the SIU, the tribunal has not made a finding on the validity or otherwise of the agreement. So it would have been premature for us to go now there and say, well, we would like to sue out of this, where we know that we lawfully complied with the prescripts. And that is the difficulty which we have. And for that reason, we say practically, it makes sense to combine the two processes, where the tribunal are called upon also to deal with the conditional counterclaim.
Yeah, no, I follow that. It's just that, yes, you know, it was something that it concerns me. Obviously, if I find that there was for example, that the contract was illegal, you know, you can, as in all parties, say, well, in this case, you can't even say carry on because the contract has been concluded and finalized. You
Yes.
just say, well, I make that order, but nothing further. And there's no reason why anybody should give back what they've received. It's 3 years down the line, and that's the end of the story. But you know, you're asking for specific relief based on actually the common law. But anyway, please argue the matter, and I'll try and not to interfere too much, and see whether we can not finish this by in the course of by 12:30. What are we now? 11 o'clock, 12 o'clock. Can we look at 12 o'clock?
No, we definitely will, my lord. I intend to just highlight certain aspects. Just to put a structure before the tribunal, I will raise the issue partially with regards to the point in the first point in limine, and then I'll deal with the second point in limine, and then I'll deal with the merits of the matter. And I have, to the extent that I have not dealt fully with the issue of the counterclaim, I'll also then deal with the counterclaim in its entirety. And also with reference to that, to the approach followed by the applicants, I'll also deal with that in due course. My lord, just one observation before I actually before I jump into my first point, is that on the face of it, it would appear that the submissions advanced by the applicants, or the first applicant in particular, appear attractive if one have not regard to the case made out in the filing affidavit, read together with the replying affidavit, as well as the issues raised by the different respondents in relation to those issues. So I would urge the court then to deal with that particular aspect in the context of the case made out by the applicants in their pleadings. Now, the court have somewhat said that I will approach this matter with a practical or pragmatic approach, in the sense that there was a delay, but the delay has been explained. We persisted with the view to say that if one have regard to what Justice Cameron have said in Kirkland, is that the respondents are entitled to know exactly what was the causes of the delay and why the matter, it took the SIU 2 years to institute the proceedings. For that reason, we say that the delay, as it appears on the papers, are unreasonable. And I've referred to Kumalo, and I've also referred to Kirkland, and in particular also referred to Buffalo, right? But even if the court were not with us on that particular aspect, there is a particular legal proposition which is put forward by the Constitutional Court. When you deal with the second leg, namely, would it be in the interest of justice to overlook the delay? And that's something which my learned friend has not touched upon. There, the question is, you then have to ask yourself the question, and Kojima is very clear on that. It's referred to at paragraph 50 in Kojima, at page 346, where it says
5050 or 15?
as paragraph 550, and it's at page 346.
Yes.
In particular, the question is, when one deals with the issue of the critical consideration, is the issue relating to the merits of the impugned decision. In other words, to what extent did the agreement itself did not comply with the prescripts of the regulations? And we must, I mean, let's just pause here, that the entire case of the applicants is based or founded on a non-compliance with regulation 36 and read together with regulation 37. And to some extent, they seek to rely on circular, or the guide circular 100. They say that there was non-compliance in that relation. I will come back in a minute as to why we say the issue which we need to deal with needs to be dealt with there. Now, the unlawfulness of the impugned decision must be clear and undisputed. Now, without more, my lord, it's clear from the pleadings that the issues between the parties are highly contested. Each and every point is contested by both parties. To some extent, there's even disputes of fact raised, and the applicants have never asked this court for relief or a direction that the matter be referred to oral evidence. They base their case simply on the fact that this tribunal must make a finding on the basis of the pleadings as they appear. To that extent, as the court correctly stated, is that the court must then on Plascon Evans find whether the version put forward by the respondents are so far-fetched not to be accepted as correct. We state the contrary. The respondents state, first and second respondent in particular, stated it is instructive to note that their version has to some extent or to a large extent has not been disputed by the SIU. And mainly on the basis that the case made out by the first and second respondent is founded on the fact that they have rightly concluded an agreement with the municipality at the time. Now, the whole issue as to how the agreement came into being was on the basis of a deviation, which was at the time conducted or issued by the relevant municipal manager. It is not the SIU's case, nor does the notice of motion state that the deviation is the subject of a review on a setting aside by this tribunal. So the deviation as it is stand. It is not something which is attacked by the SIU.
But can one deal with it on such a literal basis? What they say is the contract itself or the decision by the third respondent to purchase the personal equipment.
Yes.
That is irregular. Now, surely is it not wide enough to deal with the processes prior to that, which would include the deviation at that stage?
No, my lord.
In fact, the deviation was something that came in after he had already stated that the transaction could be concluded.
Well, that is the version which the SIU want this tribunal to believe. The deviation took place, and that evidence is not disputed in Jenna's affidavit itself. The deviation took place on the 3rd of April.
That is now during this verbal communication.
Yes, my lord. But perhaps I should pause here to state the following: is that it is in as much as the SIU would like to seek us to understand that you need to follow all the processes, but that cannot take place without having proper regard to the context. And the context which we refer to here at the time is that on the 26th of March 2020, there was a lockdown announced. And in April, it was into the second month of the lockdown. It is also common cause that at least on March to the 24th of March, that the municipality at that stage knew that they have no stock of any PPE. In other words, the need to protect their workers and the persons who's performing the normal task of the municipality at that stage was known as early as March of 2020. So the emergency issue which arose, which was then finally come into being in the beginning of April, that emergency ran over from March into April.
Yeah, but what they did was they had this COVID-19 committee. They decided to, well, listen, let us just get rid of them. And we appointed a new committee, and all of a sudden, this Mr. Jenner is the one that got this quotation, the single quotation, whilst there were at least 4 other quotations. Is that not, does that not appear to be strange to you?
No, my lord.
Whether you want to say that Meyer acted incorrectly or not, but it appears to me as if they wanted to get rid of Meyer and her committee, and then all of a sudden, within a day or 2 days, there was this new contract or person found that was prepared to deliver goods to the municipality.
My lord, if that was the facts, then I would have readily conceded. But that's not the facts.
But if it is it not like that? Is it not so?
No, my lord. It is not so. I think what happened is that.
Yeah, no, let me just say to you what I.
Yes.
There was a COVID-19 committee.
Yes.
With people there, and they got quotes. Now, whether rightly or wrongly, whether there was a problem there, I'm not too concerned about that. All of a sudden, on the 1st or the 2nd, and whether it's a municipal manager or the mayor, but they got rid of these people, mayor included, though she was suspended. And that same day, the 2nd or the 3rd, all of a sudden, here comes this new man on the block, Mr. Jenner, and he was the one that was now dealing with COVID-19 procedures. And he, after having, there was consultation between Clarkson and Hendricks. All of a sudden, first respondent was the one that made the quotation. Is that not to get rid of the others and then to appoint these new people that were in cahoots with each other?
No, my lord. I think that is not even borne out by the facts or the case which was brought by the SIU. What we do have is that the reason why Meyer was suspended is because Meyer was committing irregular activities.
Well, the same that what happened here. She was asking that there should be a deviation based on an oral version and not a written document. But the point is that all that I want to say is the one group of people were replaced by another group of people, and all of a sudden, Jenner, consisting of one of the members of this new group, within a day, appointed or arranged for a single quotation or a quotation from a single person, and forgetting about the others.
But that is not entirely how it happened, my lord. That's not entirely how it happened. Because I mean, if and again, let's go back to what the pleading side. The pleading state is that the first respondent was invited on invitation by Jenner. And that invitation, he subsequently then submit a quote, which quote was then considered. And it is clear, my lord, it's if you have regard to what Jenner has done in his affidavit, right? Jenner has made an assessment of what the needs is, and he was appointed in that particular position. He made an assessment of what the needs were. And the needs for PPE was at the time that they did not have sanitizer, did not have gloves, and their workers were exposed. He conveyed the information to the relevant authorities, and they then took a decision to award it. The question now is that there was a deviation, the deviation which was agreed, and the court earlier referred to AK-16. AK-16 at page, which clearly dealt with this particular aspect. Where the courts will see is that AK-16 where if the court will have regard to what is stated at 263 is that where Jenner where the discussion is clearly directed to say that we, however, have confronted with an urgent need to protect our essential team operating in these difficult circumstances today. Also, Mark, and then he dealt with the further issues that is now set out in that particular email.
The point is,
And if
everybody
the
in the municipality was aware of this already in the previous week.
Yes.
That is apparent.
But
and people were in fact asked for quotations and they got that. And then there's an issue of whether the closing date was the 1st of April or not. I'm not too much concerned about that. The point is they got quotations, and when this new bloke on the block came, he just disregarded those, got a quotation from a single person saying that they could not find any other people that have got goods in stock. And then when he eventually sent the emails, it appears that he sent to this this first respondent emails wherein he attached the other quotations. For what reason? He said to get his books right. Oh, but that is ridiculous, to say the least. That is absolutely nonsense.
My lord, that is for Jenna to explain. All I can state to you, my lord, is the following. And this is what the undisputed evidence are. The undisputed evidence are that there were certain recommendations made to accept, to deal with what the first respondent have said. And the fact of the matter is, the first respondent, when the quote was essentially accepted, he submitted his quote, and his quote was then accepted on the 7th. And then confirmed on the 8th. He made delivery on the 9th and the 10th of April, which is the following week. Here is the striking point, my lord, and it's something which the court will have to consider. And I know that the court say we should not repeat the actual wording of particular regulations. But here's the
I didn't say that. I say that you must not read every of that.
Oh, yeah, sorry. I did not read it out.
Specific one, you're entitled to do that.
No, sorry, my lord. The specific one which I would like to just make reference to, and it relates specifically to the issue which we're deal with now, my lord. It's the issue with regards to what are the requirements of Regulation 36, right? There we have, if one have regard to the wording of what the regulations say, the regulation in itself it's cast in very wide terms, right? It say that that the particular person or the municipal manager or officer can use any appropriate method, right? But the requirements, he must comply with the requirements. The requirements are that there must be an emergency. And it's common cause that there was an emergency. And the goods or services must be available. It is common cause that it was agreed that the goods were available from the first respondent. Or it was practical or impossible to procure the processes from somebody else. Now, the accounting officer was within his rights. It's not the SIU's case that the accounting officer at the time was acting contrary or was not permitted or entitled to invoke Regulation 36 for the deviation. Now, if we accept that the deviation occurred as it has, the goods was supplied, then if one have regard to Jenna's version, that the first respondent or Duneco was in possession of the goods. The fact that it sourced it from its suppliers is neither here nor there. The fact of the matter is the goods were delivered. And that stock was, that Jenna also said that the Duneco was able to supply the stock. And one thing which we must not take out of the equation is the following, is that that particular email was accompanied by the quotations from other suppliers also. It was not only Duneco's quotation. There was other quotations also. So on if one have regard to that, then it's clear that Jenna must have regard to the content of, or even the recipient of that email must have regard to the quotations which was furnished or forwarded to that particular person. So on the face of it, it would appear that there was compliance, that the deviation as it stands has been complied with. So the agreement then came into being. One, there was a purchase order, and we know from a supply chain perspective that once a purchase order is being issued, the agreement came into being. And then Duneco supplied the goods, the PPE, to the municipality. The goods was received by the municipality. And it's clear that the information which Duneco was furnishing, it states that delivery took place of all the goods. One of the complaints by the SIU is that there was non-compliance with Regulation 36.2, i.e. it was never recorded or reported to council. Now, the Mototac matter, which is referred to by Jenna in his heads of argument, makes it very clear, is that it says that a failure to report timelessly in itself does not vitiate or water down the lawfulness of the issue. It still remains that there was a report in the following year. And again, as been stated earlier, that council did not sit regularly because of COVID. So when council had the opportunity to sit the following year, the matter was reported. And it's not disputed that
Excuse me, I must say that I haven't considered that carefully. I believe that because people were referring to July or August, I was under the impression initially that council started to sit again either in July or in August 2020, but then I also saw somewhere that they were referring to 2021.
Yes,
what is your view? Did the council not sit at all for more than a year?
No, I cannot completely say give information on that. From the papers, it appears from Jenna that he said that council was sitting in August 2021.
So that's more than a year, like for the first time.
That appears to be the situation, my lord. I do not know what was the reasons behind it. There could be, I think Mr. Titus could be in a better position to explain whether there was any sittings in 2020.
Yeah.
But what we do know, my lord, is that the contract was also recorded in the financial statements of council, and that is a point also again made by Jenna in his heads of argument in his affidavit.
Yes.
Now, there were, to emphasize, it's worth repeating it, to emphasize the point is that the first and second respondent makes the point to say that there was delivery made of the goods, which was done by the service providers. And I hear the court, when the court earlier say that there was a set-off made in relation to one of the suppliers. Now, there's nothing unusual about set-offs in a business transaction, because if your supplier was owing you or you have a credit with a supplier and you ask the same supplier to provide you, it happens on a daily basis. There's nothing unlawful or irregular about a set-off made by a particular supplier.
Yes, no, I'm not taking that point at all.
Yes,
I was just referring to the fact that that's how those two transactions happened. Yes. In the one case, there was clear proof that, well, on the papers of the respondents, that the one entity in fact delivered a certain amount at a certain price, and payment was made.
Yes.
And in the other case, the entity delivered, but there was no payment sent by the first respondent or proof of payment, but the first respondent said, well, there was a set-off. They owed us money, and as a result thereof, there was no payment made to them. No, I'm not saying that that is wrong or that I should frown upon that or anything. That's not the issue. The issue is that these people, and that's what I said, there are third parties that made affidavits as part of the proceedings before me. It is so that during the investigations, there was apparently no reference by either Jenner or whoever in respect of these deliveries. But the point is, I'm now confronted with these affidavits. And can I just reject that? That's the point that I wanted to ask.
And we make the contrary point, my lord. I'm thankful that the court is clarifying that position. We make the contrary point. We say that those two affidavits from the suppliers are part of the pleadings which supports the version of the first and the second respondent. The SIU set up no rebuttal or no case or refute any of those allegations. So to that extent, in order to prove the position of the first and the second respondent, we submit that the court or the tribunal is within its right to accept that as part of the adjudication of the matter which is before this tribunal. We must also say, and perhaps it's an opportune time now to sort of interject and say, well, if the court have regard to the approach followed by the SIU, then we sit with a situation that a large part, and this is in the context of what has Jenna and the other person say during the interview or not, and whether they've now changed their version. If one have regard to the founding affidavit, read together with the replying affidavit, it would appear what the SIU was doing is that the founding affidavit, the reply affidavit, is largely based on hearsay evidence, which is not supported or corroborated by any person who was inside or who was actively involved in the procurement process in April 2020. We have a supporting affidavit from Mr. Sias, but we know that Mr. Sias only joined the municipality almost 2 years after the fact. And on his own affidavit, he said that he joined in February 2022.
No, that is so. I mean, what happens is that I accept that, but what happened here is that the deponent to the SIU's affidavit, who was involved in the interrogations, was relying on information that they received from Jenner and from what's his man's name? Hendricks and even Boyson. So they did their investigations, and I agree insofar as they rely on other evidence that they haven't, that would be hearsay. Obviously, it's hearsay. But the moment that they refer to what Boyson and Hendricks and those people, that are parties to this, Boyson, Hendricks, and Jenner, what they said is obviously that cannot be hearsay pertaining to this because they are parties to the application. But surely, insofar as they rely on other evidence and they haven't told us where they got that information, that would be hearsay, and there's no application to have that admitted. But I think eventually what's happened is there was this investigation, and all the parties, well, especially the three employees of the municipality, got the opportunity to explain what happened.
Yes, but we have a slightly, the first and the second respondent makes a slightly different point. In relation to, it would appear, if one have regard to the founding affidavit, read together replying affidavit, that the deponent there to revert to an interpretation of what the outcome of that investigations are, as opposed to actually saying, as a matter of fact, this is what happened. What he is doing in his founding and replying affidavit is to say, you have said that in the investigation, therefore the inference must follow, or it must be inferred from what the investigations say. It must be inferred to that constitute a fact that this is what your position is. The answering affidavits cast a doubt or a shadow over the manner in which the deponent to the SIU's affidavits is putting his case before this tribunal. And to that extent, my lord, we say that the assumptions which they sought to draw, the interpretations which they seek to make, and the conclusions which they seek to draw from the founding papers, read to the replying affidavit, is not supported by any independent evidence. And it's not enough, my lord, with great respect, it's not enough for them to merely attach the affidavits which they got from the investigations as a manner how to prove their allegations which they make in this proceedings. In this proceedings, they make it very clear in the notice of motion. This application will be supported by the affidavit of the deponent, meaning Mr. Kok and Mr. Sears. Those are the parties which they rely on in support of the affidavit. They do not go so far as to get an affidavit or corroboration from Wilbus, who was the person who allegedly received the delivery or took delivery. They do not get any affidavit independently from Mr. Kunana, nor do they get any affidavit from Mr. Farmer or from Meyer. None of those persons. What they have done is to adopt the sloppy process to say, well, we will rely on this information almost as a basis that this tribunal is now called upon to read in those findings of the investigation as forming part of the founding papers and the replying papers. Right. And to that end, my lord, with great respect, we say that that is not an approach which is appropriate for application or motion proceedings. They need to make, with reference to the specific documents or attachments, they need to say on which aspects are they relying on, and to what extent that aspect is supported by an affidavit from an independent person. Then again creates another problem for them. So the allegation or the averment from Mr. Jenner, which he made in paragraph 111 of his affidavit, where he say the following, my lord. He say that the full amount of 25,000 gloves and 10,000 masks were delivered to me by the 11th of April as set out above. So we have no, as outside parties to the municipality, we have no reason not to believe that he received the information or he received the documentation after the delivery of the PPE. We
Well,
then say
you say that you have delivered, so he's just corroborating what your client.
He's corroborate our version. And that's enough for us, because we say that we have, if the court were have regard to our averments in the answering affidavit, read together with the annexures which we attach to say who delivered it, read together with the payments which we make in relation to those deliveries, read together with what Jenner say in his affidavit, we have a consistency of corroboration, something which is different from what the SIU is saying. The SIU does not have any corroboration to do that. All they say, they make the bold allegation to say, well, there was less delivery, i.e. there was only 1,000 masks. And they say it's on the basis of what Wilbur said. We don't see any information or any corroboration from Wilbur. So to that extent, we say the court cannot even rely on that averment in the deponent's affidavit.
Yeah, no, the only point that I want to make is that Jenner obviously corroborates your client's version.
Yes.
That doesn't mean that I've already made up my mind that Jenner can be believed. But my problem is that you've got these two independent people that gave affidavits, and whether I can say that based on the papers before me that I can reject their versions as false and fabricated because they wanted to support your clients. that's very difficult for me to make such an assumption or to come to such a conclusion. But that doesn't mean that I may reject Jenner and say, well, he was talking, he contradicted himself, and it's obviously an afterthought. I'm not saying that, but the mere fact that I reject Jenner's version doesn't mean that I've got to reject the two independent people that said that they delivered.
Yes. Just the 2 points, just to clarify that point before I move on, my lord, is that we submit that the two independent persons' affidavit must be accepted by the tribunal because they're not disputed in any way. We say with relation to what Jenner's version is in his answering affidavit, we say that nothing is insufficient amount of rebuttal is put up in the reply by the SIU for this tribunal to reject Jenner's version in its entirety or even in part. We say to the extent that the court were to reject that particular aspect, i.e. the issue relating to the delivery, that raised the dispute of fact, because we know that the SIU was never actively or directly involved in either the receipt of the delivery of the PPE, nor were they the persons who knew what was happening. They rely squarely on the outcome of the investigation, and now to some extent they also rely on what SIAS is saying, SIAS inquiry. But the difficulty of SIAS, he came 2 years after the time. Again, it makes it difficult for the tribunal to even rely on his version, partly or wholly.
What is strange to me is that these goods were not stored in the places where they were supposed to be stored, and there's also a difference there as to where these were specifically stored, which goes back again to the veracity of the version of Jenner in particular.
My lord, to the extent that I can answer that by way of a legal proposition, because Jenner should answer that. It's when we deal with a motion proceedings, the court is given a version by the SIU, right? The SIU in the filing papers and replying papers do not positively state that when you receive the PPE, you're supposed to drop it off in the PPE box, or it must be received by a particular person. We know it was strange times. It was unconventional circumstances. So Jenner was the person assigned to deal with the PPE at the time. And there's no evidence to say that his appointment was irregular or he was not entitled to deal with a particular matter. We also know that the department, that the municipality was working on the basis of skeleton staff. So he makes it clear in his affidavit to say that he was from time to time also trying to assist where the other persons were not able to assist directly. So to that extent, that information in his answer affidavit still is reliable information, is reliable testimony of what he was doing at the time or called upon to do at the time. So to that extent, and it's not refuted directly by the SIU. So we say in those circumstances, we say that, well, sort of the court the tribunal must take into account the version of what Jenner is saying with regards to the delivery. So we say the best for us to say is, as an independent person standing from the outside, we say we've delivered the goods to the municipality. What the municipality have done with the goods subsequent to that, it's something which we cannot attest to because we're not part and parcel of the municipality. At best, we could say we have delivered the goods.
Yeah, I think you've made the point there. Yes. Is that whatever the issue of Jenner is that your clients say that we've delivered.
Yes.
Anything else?
I just need to take. May I just take one instruction from my client, from my attorney?
Yes.
Yes. Yes. Just one point, my lord, that just to make sure that that it is also stated in the affidavits. I cannot now give the correct page reference number, but the averment is made by I think it's either Kunana or somebody who say that there was a distribution of the PPE which was received.
Yeah, they say so. Yeah.
Yeah. Now, can I then turn to the second point?
I was wondering because
Yes.
I thought this was just a small little one street municipality. But apparently, as what I did was is that I just looked up, and I perhaps should not, but I say to you that I wondered why would you need 25,000 of this and 20 of that and 20,000 of that, but I thought that maybe they only had 10 workers in their employ. But this municipality, and anybody that wants to dispute it must do so. But apparently, this municipality consists of various towns: Inter Alia,
Yes.
Lutzville, Van Reinsdorp, and I don't know
Yes.
what in the community. So we're not talking of one street
No.
town with 10 employees in it. It's a lot of people that are employed there, and also a lot of residents in the various towns.
Yeah. Just to add on that, my lord, it's just the tribunal can take judicial notice of it. It consists also of fishing communities, which is in and around that particular area. So it's not only about the town itself, but it serves also the fishing community, which is part and parcel of that particular, which are in towns which falls part of the municipal jurisdiction of
Why
the sector.
Why should the municipality give gloves and masks to residents?
I'm not, no. That's not the point I'm making. That's not the point I'm making. I'm making a different point. I'm just saying it consists to add on or amplify. It's a larger community which it serves.
No,
and it could be that. Yes. Yeah.
No. I've seen that. We're talking of like in 5-6 towns and the rural areas, and it's not the one little one-horse town that I thought it was.
No. It's actually larger than that, my lord. Now, if the court were to accept, which the court must, that the deviation was in accordance with what the regulations say, and that the agreement came into being, and even on the SIU's own version, that they must accept that there was an agreement, even if they try to characterize it as illegal. They have not done enough to show the illegality of that, and I'm coming to that shortly. The court will see, and it's something which I need to draw to this court's attention, is that to say that what the applicants is doing in paragraph 24 is that the court will see there's a reference made to section 217 of the Constitution.
Yes.
But there's no factual averments to say to what extent there was a non-compliance with that particular section. So no finding can be made in relation to that.
Well, I mean, it's obvious what section 217 says, but that is not. I mean,
it's not their case.
A proper. I mean, it's clear from the evidence and all the evidence. Your client will also agree with that. There was no compliance with section 217, but you say because of the emergency. And
yes.
So it's a different scenario. It's easy to say. They didn't say specifically it wasn't because it wasn't in terms of a fair procedure of this or this or this. But one can see that there was no compliance, but that's not the issue. The issue is whether there was compliance with the circumstances there, bearing in mind it was COVID and it was emergency and that kind of thing.
And we submitted there was compliance, my lord.
Yeah.
The other point which we try to make is the following: is that the founding affidavit does not make out a case for review on the basis of rationality. That's the point which they refer to at paragraph 24.2 of the heads of argument. Now, the other point, again, which was also not part of the founding papers, is the reference made to the directive of the Disaster Management Act. Their directive, there's no case made out in the papers or the founding affidavit or the replying affidavit to say that that the circular is saved by the regulation which the applicants are referred to in paragraph 34 of their heads of argument. This only comes out in argument. It is not something which is set out in the affidavit. So we know, and the applicants or the SIU agreed or conceded thereto that circular 100 was not approved by council as required by section 168 of the Act. And we know that in as much as it was COVID or it was unusual circumstances, there was no regulation or act which repealed the application of section 168(3) of the Act. So the legislation was still in place, and that legislation should have been complied with. The fact that council did not sit at the time does not remedy the situation, because council was in principle, council was able to have sit by way of online methodology. Now, if the regulation or if the guide was not accepted, that guide in itself does not carry any legal efficacy to allow the SIU to say that you could still rely on circular 100 for purposes of contending that there was non-compliance with the circular. We submit, because the circular was not accepted, that for that reason alone, and in light of how this whole thing unfolded, that we say that for that reason alone, that you will have to say that the manner in which the agreement was concluded at the time did comply with the requirements which was stipulated by regulation 36(1) of the regulations. And on the evidence, we know that the first respondent of Duneco was invited to submit his quote. Now, what the SIU seeks this tribunal to believe is to say there was a relationship between the second respondent, or the first and second respondent, in particular Mr. Hendricks, which was untoward, or which forms the catalyst for why the agreement was, or the contract was awarded to Duneco. We say that they have not done much to show or demonstrate an unlawful or irregular or unfounded relationship between the parties. The mere fact that Mr. Klaasen and Mr. Hendricks knew each other because they were born in the same town in itself is not unlawful. And in itself does not say that in itself can constitute sufficient basis for the type of relationship which is required by the supply chain management. The supply
excuse me, but that may be so. You meet each other, it's a relatively small place. The one town where the general office or municipal offices are in Williston. It's a different story from when you, as municipal manager, is being asked to give your wife's bank details to somebody that 2 weeks later is the only one that provides a quote for goods to be delivered, not of 10 rand, but of 400,000 rand. I mean, that's a totally different scenario of the one that you try to explain to me here.
Perhaps with the difference of the following, my lord. The difference of the following is that that contact details were given in 2019.
No. 20, was it not March 2020?
It was the previous year, my lord.
Are you sure?
Yes, my lord.
Okay, no, well, I'll have a look at that. I thought it was.
But even if that, because the wife in itself is not been saying that because the agreement, it is not the SIU's case to say, well, that a contract was awarded to Duneco on the basis of the connection between the contact details or the money given to the wife or wherever the money was given and the person who actually worked for the municipality.
No, but there's a difference. The point is here is that we know all these people that are, I'm not saying that's what happens here, but all the crooks in this country will not have bank accounts where money or illegal money are flowing into. They've got various trusts and CCs and family members where the money goes into. If this client of yours had a direct relationship with Hendrik's wife because they needed to pay money over, he needed to pay money over to her or whatever the case may be, he would have contacted her directly and say, Claudia, whatever your name is, just give me your bank details. Why did you have to go through the husband? The husband is probably the one, well, the connection that I make at this stage is it's an inference. It doesn't mean that is the only or the reasonable inference to be made in the circumstances, but it's surely an inference that money was to be paid over to Hendricks, but they didn't want to use his bank details. Therefore, they asked for the wife's details so that the money can flow to the wife's account. But that's something to be considered by me. That bothers me and it concerns me.
My lord, I think it would have, if in the context of what my lord have now explained, it would have been a concern if the money paid to the wife was almost a prepayment for the contract which was received. But there's no relation drawn between what was paid to the wife and the contract which was finally awarded to Duneco. There's also no causal connection between that any money was paid directly to Hendricks, even subsequently or before, by the first and the second respondent.
Yeah, well, that is so because it will very seldom be for anybody, the police or whoever, to be established. But I would have expected Hendricks to say when he was investigated or in his affidavit to say, well, listen, this is the situation. Mrs. Hendricks, my wife, bought a bicycle from Mr. Carson, or the other way around. Carson bought a bicycle from Mrs. Hendricks, and he needed to find out where can he put in the 5,000 rand for the racing bike, something like that. But just there's nothing. That is a vague generalization, as if, listen, nothing has happened. That's my concern, and that goes to the credibility of the people involved. That is now Hendricks and your client, the second respondent.
My lord, with great respect, I think there is not sufficient amount of evidence put before you to put in question the credibility of either Hendricks or the first and second respondent, and that is made plain from I would like to refer the court to paragraph 174 and 175
From what?
It's at page 348 of the answering affidavit.
Yeah.
Where, if I may, my lord, because of its importance, it's stated as follows: that the SIU stated unambiguously under oath that I loaned money to Hendricks. That's not Klaasen. My attorneys addressed a letter the 1 July 2022 to the applicant's attorneys.
Yes, now I've seen that because
Yes.
they jumped to a conclusion that there was in fact a loan.
Yes.
But what is clear is that there was a bank details requested.
Yes.
And the question is what happened to those? What was the reason for that? And there, Mr. Hendricks, and also then your client, but let us just deal with Hendricks.
Yes.
You can't speak for Hendricks. He just didn't want to tell the SIU investigators what the issue is. And even now today, I'm still uncertain as to what the reason was that there was bank details provided of his wife to the second respondent.
But the case before you, my lord, is this: is that on the SIU's own version, they say they're unaware of any loan agreement between Klaasen and Eldrick, right? The SIU furthermore was unaware of any terms of the loan agreement. So in other words, what you have before you, my lord, is that the case which they call the tribunal upon to deal with is a situation that they say, well, because of this relationship, there was something happening. And upon further questions and upon further inquiries, it was then asked for them to explain exactly what they're saying. So the version on the Plascon evidence is that the court must accept the version of the first and second respondent at best.
Can I ask you the following? If you've heard that I'm going to postpone this matter, I'm not going to give judgment today. We
Yes.
wait for the fifth respondent's heads or whoever's heads of argument. If between now and judgment in this case, you would send an email to me,
Yes.
asking my bank details, and I give that to you, my bank details.
Yes.
And somebody picks that up, what would they believe? What is the only reasonable inference to be drawn there where we don't know each other?
Well, my lord, it's open.
What is that?
No,
That I've got to give a judgment in your favor and you're going to pay me something. So the only reasonable inference.
No, my lord. The other inference is that it could be a loan. It could be in advance. There's multiple answers to that, my lord. It's the inference which the SIU would like the tribunal to draw, namely it was a loan in relation to, or it was money in relation which deals with the agreement. There's insufficient amount of evidence to support that inference, my lord.
The inference is that the two of them know each other so intimately that 2 days after Hendricks got the job in this little town, he was contacted by his friend who agreed with him that the friend should, through the process, give a quote for PPE goods to be delivered. So well connected with each other. You're not going to make any change my view on this. That doesn't mean that I've got to grant the application. All that I say is that's an aspect that I'm firm on.
But my lord, with great respect, I think therein lies the problem. The problem lies in the fact that it is not supported by the evidence. That particular, the conclusion or the inference which my lord is just put forward.
Oh, obviously, because both of them, they would try to water it down and deny this. Both Hendricks and Carson would deny this. So where's the other evidence? Now you've got to get somebody that say that we saw them going on a holiday in Spain last year, or whatever the case may be. It's very difficult to get much information in a case like this, where people are in cahoots with each other.
Unfortunately, my lord, it is for the SIU to put sufficient amount of evidence to allow the tribunal to draw the inferences which are supported by the evidence. If they do not provide the tribunal with evidence which will enable the tribunal to draw those inferences cannot be drawn. And that's the law of evidence, which makes it very clear is that in these circumstances, the inference cannot be drawn that they were in cahoots. In any event, my lord, there's not even a shred of any evidence to show there was a collusion. It is not the SIU's case that either the first or the second respondent were aware of what happened inside the municipality at the time after they've submitted their quote. It's not the SIU's case that they in any way have influenced either Hendricks or Jenna at the time to make a decision in their favor. That is not the evidence which is before you. All they say is that this quote was received and it was submitted. And this quote was finally then taken to be the only quote which was then dealt with. But what the SIU left out is to say, apart from the quote from Duneco, there was also another quote which was also submitted together with the other quotes. It's not enough to say that the other quotes were given as window dressing without corroboration for that averment or that conclusion which you seek to draw. So in those circumstances, my lord, again, based on Plaskon Evans, is that the tribunal should make a finding on the basis of the first and second respondent version.
Second response version. That would mean is that the application should be dismissed.
In essence, my lord, because I mean, if the application must be dismissed, because if you have regard to, and again, that's what the case law is actually saying to you, is that they say that the issue of the illegality of the impugned decision should be clear and undisputed. Here we have the issue of the award of the contract has been disputed from the get-go. In other words, there's a dispute between the parties from not only in the manner in which the agreement was awarded, but also as to the outcome and the persons involved. And both of them raise issues of a dispute of fact on different levels. So if the court were to make a finding on the affidavits only, then the court must then say, well, on Plaskon Evans, I must accept the version which is being put forward by the first and second respondent in relation to the agreement. And for that reason, the court must dismiss the application, because they have clearly shown, their conduct is clearly shown throughout that they provide sufficient amount of evidence to show the court to come to a different conclusion. In any event, my lord, there is no evidence to show that there was any collusion in its technical term or even in its general term. There's any collusion between the first and second respondent and any of the other respondents. What we have is there is an assumption, and the assumption is based on this alleged the alleged friendship between Hendricks and Mr. Clausen. And they try then to make the leap by saying, if you have that friendship is actually the catalyst, which was in my learned friend even went so far as this, it sort of smacks of corruption. But there's no proof of any form of corruption on the part of the first and second respondent. There's no proof of that they have in fact have influenced the procurement processes from the get-go.
Right. I think that is basically the case that you've want to argue.
And just my lord, before I step off that point, is that the issue relating to the counterclaim. I've already earlier stated the issue to the court as to why the counterclaim should succeed in the event that the court is not with us in relation to the dismissal of the application. But may I just, my lord, my learned friend has committed the error by stating that or characterize the first and second respondent as not being innocent parties. And for that reason, they cannot take any benefit. They should be punished by way of not having any benefit to be taken. Now, may I refer the court, my lord, and this is a very recent judgment.
Excuse me, can I just ask you, can I just for 3 minutes ask to be excused? I'll be with you now.
That's fine, my lord. That's fine. Huh? Ik praat nog van de leservaring, David. Ik weet niet wat ze zeggen. Ik weet het niet van.
Are you there? Are you there? Can you hear me?
Yes, I can hear you, my lord. I can hear you.
I was thinking it's about like in the old days when I was still a young attorney or advocate, and you get to the magistrate's offices in the countryside, and the guy would say to you, the magistrate would say to you, listen, my telephone is ringing in the office. I'm just going to answer it quickly. Anyway, so you were on the verge of referring me to recent authority.
Yeah, recent authority, my lord, is it's a case which came out the 3rd of April 2023.
Sure.
It's a matter of the SIU. It's in the Supreme Court of Appeal. It's the one versus Rebosis, and the neutral citation is Special Investigating Unit versus Pomelo, and you spell that as PHOMEELA Property Investments, and another case number 1329 of 2021, and in brackets is 2023 ZASEA at 45.
Delivered last week, the 3rd of April.
Yes, my lord.
Okay,
And
yes.
that essentially deals with the issue which my learned friend has also have dealt with in paragraph 16, in particular, with regards to the issue of the innocent tenderer has no right to retain what it was paid under invalid contract, right? There, the SCA makes the point very clear. They say with reference to a contextual reading of the dictum in all pay, clarifies the matter. The Constitutional Court did not require cash pay services to repay amounts paid to it under what was found to be a lawful contract. In the exercise of discretion, the Constitutional Court ordered a new tender to be issued, but that if the tender the tender is not awarded, the declaration of invalidity of the contract in paragraph 1 above will be further suspended and until completion of the 5-year period for which the contract was initially awarded. In other words, there, it's very clear, my lord. It's in, again, I will not read paragraph 17.
Yes, but
In
that was
18.
you referred now to the all pay case. I accept
Yes.
that, and you say in this case of Pomela, you refer to which paragraphs? Paragraphs.
Paragraph 16 and 17 and 18, my lord.
I'll have a look at that.
Yes.
The point is that the innocent tenderer is entitled to claim back or to
Retain.
to retain what he has
Yes.
received.
Yes, but
that's-
what is different, my lord, is that there we're dealing with an invalid contract, where the court even went so far as to say that in those circumstances, that particular person of invalid contract can retain.
Yes.
So similarly, we say that if you take the corollary of the corollary of that particular principle, you say that even in circumstances where we say that the agreement was not unlawful or irregular, that it cannot then be said that we are not entitled to claim the monies back which we have expended. And it's not accurate to say, my lord, like the SIU is trying to say, is that it's not accurate to say that at best for the first and second respondent is that they are entitled only to 200,000, right? I mean, a transaction does not necessarily, in the fact that 400,000 was charged was seen to be in the context of all the quotes which was before the municipality at the time was the lowest quote. So even on their own version, if they were with regard to Sulnest, which they wanted the court to believe that was the best quote, that Sulnest was even a higher quote. And we make the point, the respondents make the point in the answering affidavit. The point simply is this: the fact that 400,000 was charged and 200,000 was paid in respect for the suppliers does not mean that the first and second respondent, or the first respondent in particular, is not entitled to the amount which is reflected in the agreement. That's how contracts normally works, is that you make a profit on that, and that's the profit which you've made. And there's not suggested that profit was unlawfully made, for example. So it does not avail the SIU to come now and say, well, you can only have 50% of the amount because you've overcharged me with 200,000.
Yeah, I follow.
Yes. Now, can I just, before I completely step off from this point, my lord, I think it's important that I just draw the court's attention to paragraph 47 of the finding affidavit.
Yes.
In paragraph 47, it's the issue which they say, a further attempt to make the transaction appear legitimate
Yes.
where they dealt with the issue in relation to the declaration which was made. The issue with regards to the relationship.
Oh yeah, no, you're referring to the declaration of interest form.
Yes.
Yeah.
Now, the point there is just simply is to say that's the point which that's the basis upon which they have demonstrated their case about the relationship. The issue of the wife only comes afterwards, and I would urge the tribunal to consider the answering affidavit against the reply which was furnished by the SIU. I make that point in the heads of argument also.
Yeah.
So we say that the first prize obviously is that we ask the court to dismiss the application.
Yes.
If the court is not with us with regards to dismissing the application, we say that we have make out a case that this tribunal should order the repayment of the monetary value of the contract, namely the amount of 400,000 rand. because it is impossible or impractical to request the municipality to redeliver the PPE which was furnished to it. Right? We say in any event, it would appear that the SIU's best case scenario would have been to say there was a breach of the agreement because they base their claims or their complaints is based on so-called malperformance, i.e. you didn't deliver all the mask or you deliver substandard mask. They should have instituted action proceedings against Duneco to say, well, you have an agreement with Duneco, you have not produced what you say you will produce, therefore we would claim that you either give us better or you repay the amount which was given to you.
Yeah, that's your advice to them. They should have done that.
Yeah.
Thanks. I think that is what you wanted to say.
Yes, my lord. And then just the issue of regards to the costs.
Of course, yes.
There's no basis for any penal cost order against any of the parties. We submit that if the court is with us, that the court ought to grant a cost order in the first and second responders' favor. And also, if the court is with us in relation to the counter application, that the court should also grant a cost order in the first and second responders' favor.
Yes.
Those are my submissions, my lord, unless the court want me to address you on any other issue.
Thank you. No, Mr. Tsigari, no, thank you very much. I appreciate your submissions. I don't think there's if there's a real need for that, I'll contact you again. But I think you've made your point. Let us hear what
Mr. Titus is saying.
Mr. Titus has to say. I know he's in the blocks, but is there anybody that wants a few minutes, 10 minutes adjournment at this stage? Can we? Anybody of you? Can we find it from Ms. Ipser?
Judge, I have no strong feelings either way. I think it would be up to Mr. Titus to make the call.
Mr. Titus, how do you feel? Are you ready?
I'm ready to proceed.
Okay. It's 12 o'clock or 12:05 now. Let us see whether you can do it before 1 o'clock.
Definitely.
All right. Okay. It's your turn. Mr. Titus.
Thank you, Judge. Judge, as submitted by my learned colleague, Ms. Ipser, the high water mark against the fifth respondent would be whether he was negligent in making the recommendation, whether it was qualified or not. And it seems that the allegation that there's some sort of collusion on his part has been abandoned.
Yeah.
Now, it's also submitted that on the version of the applicants, it's not disputed that he was not informed of any of the issues raised by Kunena and by Farmer. And just for clarity, I'll take the court to that part, relevant part in the record. If I can do that quickly.
Yes. Which bundle is it that you want to refer to?
006. Oh, let me rather do 007. Let me rather go to the answer 00765. 00765.
You're not referring to James Bond.
I wish.
Let me just go there. 007. Yes.
That will be the reply.
Oh, you want to go to the reply affidavit?
To the replying affidavit. It's important just to note that, as a judge has noted, what the fifth respondent is saying, that he was not made aware of the other invoices, the requisitions. None of that was brought to his attention.
Yeah.
Also, when Farmer informed Kunena that it's the first time that he has sight of Duneco's invoice or requisition, that was also not brought to the fifth respondent's attention. And you'll see the response to that at 00765, paragraph 146.
Let me just make a note. Paragraph
146 at para 60.
146 and 765. I've got it.
Yes. So it's not in dispute that Boyson was never alerted to the concerns raised by Farmer, in that he's never requested any quotation from Duneco.
Are you away or are you there?
I'm here. And then at 00759, paragraph 130. Applicants is stating what is the case against fifth respondent, and they state here, applicant's case is that Boyson, a senior official at the municipality, was obliged to take all reasonable steps to ensure that the system of financial management and internal control established for the municipality is carried out diligently, that the financial resources of the municipality are utilized effectively, efficiently, economically, and transparently. Now, the point being made here is that, and my learned friend alluded to this when he stated that Boyson should have done more. He can't simply shrug his duties and say, I wasn't informed. Now, that speaks to the situation that Boyson found himself in. And I think I would be remiss to paint that picture. And it starts by the email that was sent to all the officials. And that email was by the erstwhile municipal manager at that time, Mr. Phillips. And you'll find that at 00691.
Is that the one of 24 March?
March, yes. Wherein he basically says, guys, please, people are dying out there. We need assistance. Do you know of any places where we can secure this PPE? Now, that is undisputed. It's well argued in this matter as well. So that's the background. What happens next is the municipality closed its doors. As a result, Boyson, like many other officials, they are working from home. And he states that in his affidavit. He's 600 kilometers away. Who else must he rely on if not Kunena, who is the head of the supply chain management at that point? Now, if you're in that situation, what more can you do when you rely on emails and information related to you by your subordinates? Now, it is undisputed that this issue was not raised with the fifth respondent. So in those circumstances, you can only be negligent if there was a duty that you did not fulfill. And in him relying on Kunena, I can't see how this tribunal can then find that he was negligent in that he should have done more. Bearing in mind that on 24 March, there was no places who could supply any of the PPE. And then it's also not disputed that the COVID coordinator, one of his duties was to secure PPE. And you'll find that confirmation via sources affidavit. That's at 00637 of the record, 00637. That's JB3. There is an affidavit deposed by Ruben Frank Sols. He was the COVID coordinator before, and he confirms, if you turn the page over at 4.2, you'll see the bullet points there, Judge. The last one, which states om goedere aan te koop vir die veiligheid van personnel. So that fell squarely within the duties of the COVID coordinator, Jenna, who forwarded that request to Boyson. So it would not have been considered irregular for him to receive that request, bearing in mind the background.
I think one's memory is sometimes, just fades. If I can just remember how it worked in the courts and attorneys' offices and doctors' practices and advocates' chambers, I mean, there was just no way that we worked from our offices. I mean,
we were not allowed to come to chambers at all.
And I must say that if I remember back, there was at a stage of it was very difficult to get masks. I remember that quite well there in the beginning.
And this was the height of the pandemic, where people were dying all around us. May they rest in peace. Judge,
well, that's my. I just want to say that's my own. I'm not. I will not put this in a judgment, but I mean, one should be. One should recognize that
yes,
the situation was severe, but unfortunately, a lot of people made misuse of that. I'm not saying it happened here, but the point is that you always get the vultures that just you know, take whatever they can take. But we were working and in very, very difficult situations at that stage. I mean, that's where we came with this kind of virtual hearings, because we couldn't get into open courts.
Yes, one cannot divorce the times during that period and the pressure and circumstances that people were working under. And in this instance, you have the CFO not being at the office, relying on his subordinates, Kunena, and it's unacceptable to say that he should have done more, whereas he needed to rely on those who were allowed to be at the office.
Yes, no,
I'm not sure if I'm still on.
No, you are on. I take that point. You were on. What's wrong in Cape Town?
Hello?
There you are.
Hi.
You say that
you can hear me?
I hear you now. Thank you. You said that he was away from office. He had to rely on subordinates like Kunene.
Now, the point I was making was that Kunana could have stated under oath in the reply that, no, this is incorrect. I, in fact, informed Mr. Boyson of the situation, because we have to have regard when he also became aware. That was when he received the email from the office of the municipal manager at the time. And that was prior to even payment being made. Yet, that information was never carried forward to Mr. Boyson. And I don't think it's disputed that it was in fact an emergency, and the recommendation would have been proper and justified in that circumstances. So the issue, I think, is whether Boyson was given all the relevant information, i.e. the other quotations, to make a proper recommendation, because we can see from his email that he indicates, I'm recommending that we purchase via this invoice subject to SAM policy and circular 100. Now, of course, our submission is that because he's stating that, it's a qualified recommendation saying that, yes, I recommend this, there is an emergency. However, we must still follow the policy in the circumstances.
Can you just, I know that I've made, I marked it, and but just give me the page number again of that.
That email would be at
K17, or what is it?
Yes, it's 00691. 00691. And then if you turn over, the next email would be the email from Jenna, 00694.
0691
and 94 is the relevant email. 00694. That's the email from Jenna saying, dear CFO, I trust you are well.
000691 is the one from Lionel, what's his name? Phillips. And then 00694 is the Boyson, that's from Jenner.
Because are you looking for the AK one? That's in the founding affidavit.
Yeah, no, I've got that. You refer to the one that you refer to now is the one where Jenner sent a letter of 3 April to Boyson.
Yes, so what we're saying is that Boyson was authorized as the COVID coordinator to make this request. And if you have regard to who's also copied in that email.
Yeah, who is that?
Well, it's straight from Jenner to the CFO, and then that gets forwarded to the mayor. And that's the AK one. That's the one where we have the email trail.
So I think I've got that in a different volume as well. But anyway, that's the email from Jenner to Boyson.
Yes, then we have that's AK16, if I'm not mistaken.
Yeah, AK16 is on page
262.
001262.
Yes.
Yeah, that's right.
So the point I was making, Judge, is that the fifth respondent did indicate that although he's recommending it, that the purchase be made in terms of the single invoice, there must still be compliance with supply chain policy as well as Circular 100. You'll see that if you turn over to 263.
You're referring to that and recommend that we purchase as per quotation and complete the deviation.
That's correct. That's correct, Judge.
Yeah. Now I've got that. I've already marked that earlier.
Okay. All right. Now, of course, that's not the end of the transaction. Payment must still be done. Now, it's important to note that the payment request or confirmation must be from an authorized officer. Now, we know that Kunena sent him that request, and you'll find that at 006255. There's an email. It's 006255.
Yeah.
Now, of course, ordinarily, you would be at the office, documents would be completed, and
Yes.
so even in that instance, now the date that payment was made, at this stage, Kunena is already aware that there's some issue with regards to this transaction, because we know that, because Farmer says in his affidavit that I alerted Kunena as to how I didn't request this requisition. Now, even at this stage, there's a duty on Kunena to inform Mr. Boyson that there was a concern. However, that concern was never raised with Boyson. So which begs the question, at what stage was he ever supposed to do more? Because remember, there's many transactions that runs through this municipality. And if you can't rely on a head of supply chain management to give you the correct information, then there would be no way that he would be able to execute his duties. And as stated, his version is not seriously disputed. We know that they admit that he was never alerted as to the concerns raised regards to this transaction.
Yes.
So that's the case for the fifth respondent is simply this. You cannot divorce the situation at the time, which was that nothing was ordinary. They were not operating as per normal. And to say that more should have been done, this smacks of getting it totally wrong in that on the day, nobody was working as they were previously. And if Boyson could not rely on the staff under him, how can he be held accountable saying that he was negligent, he should have done more? There's no confirmation that there was any collusion on his part with any of the officials or first and second respondent. So the high watermark in this regard would be that there was a duty that he failed to fulfill. And in this instance, you're not even told what that was other than he should have called for more documents. Now, that speaks to the email dated 24 March, where there was a call for quotations. Both on Konena and Farmer's version, they never provided Mr. Boyson with those requisitions that they requested. And at the time, 3rd April, he made that qualified recommendation. He was justified in recommending a deviation be completed on that single invoice because the facts placed before him indicated that the municipality was unable to secure PPE at the time.
Yeah, we know now, and we've known that for some time now, that the crooks and the vultures came about soon after the lockdown. But perhaps at that time, there was no reason to consider that my colleagues would be colluding with other people. You know, he acted, as you say, that you want to say, he acted in good faith in relying on his officials or his senior, the people that reported this matter. And as a result, there can't be any negligence on his side. Also,
Judge, he had a 3-month contract and he left during April. That was the last that he was at the municipality.
He left in May.
In May. He started 7 Feb. So.
Yeah, I think he left in May, if I'm not mistaken. But as you say, he had a 3-month contract.
Yeah.
Contract now, 7 Feb must be to 7 May, 6 May or whatever.
Yeah, that's correct. There's not much to say with regards to the fifth respondent. I mean, the fact speaks for itself. His version is not seriously disputed. And in any event, the court is aware and alive to the fact that the Plascon-Evans rules will dictate that the benefit should be given to the fifth respondent with regards to his version in this regard. They had an opportunity, the applicants, to file further affidavits with regards to disputing his version. That has not been done, other than saying that he was negligent and he should have done more or call for more information.
Or they could have brought an action, issue summons, or they could have asked that this matter be referred to oral evidence.
Indeed, there's no such application before. Even this morning, applicants could still say, we won't proceed today. we'll rather proceed and ask that the matter be referred. I haven't done so.
Yeah. Is there anything else from your side?
I just want to confirm that there's no case made out against the fifth respondent, evident from the pleadings before you. Also, they've abandoned the allegation of collusion on his part. Our submission is that the matter should be dismissed in its entirety. Alternatively, the relief sought against the fifth respondent should be dismissed and he should be awarded cost on the same scale as what they are seeking. There's nothing more from the fifth respondent unless you want me to address something specific.
But you cannot talk for the others. What you can say is in respect of yourself, your client.
My client, yes. That's what I'm saying. The case against him.
With respondent. And you say that they want cost on a punitive scale, so you want cost on a punitive scale. Or
of course, you noted, Judge, that we needed to fight to get the further affidavits of Kunena. And you have regard to the notice, the Rule 3512 notice. And that was very instrumental in obviously supporting his version, in that he was never in the loop when it came to the requisitions, etc., etc.
Thank you.
Oh, Jesus.
Well, we're back at Ms. Ipser then.
Thank you, Judge. Judge, I don't think I'm going to take terribly long, so perhaps we should just go and see how long this takes.
Yeah, as I said, there's an half an hour to 1 o'clock, unless some of the parties want to. You know, we haven't taken a long break. If somebody wants to have a short break now, I mean, we can deal with 5 or 10 minutes. Are you fine?
I'm fine.
Are you fine? The other people?
I'm good, Judge. I think if Ms. Melanie Ipser is going to be the only person, we can just push through and complete the matter.
Okay. If you're happy, are you happy, all of you?
Yes.
Okay, so that's a reply from Ms. Ipser.
Thank you, Judge. Not sure where to start. Perhaps I should just deal with the fifth respondent while it's fresh in my mind. Judge, it's all well and good to say these were unusual times and nobody told him. But the fact of the matter is that the fifth respondent is a senior official in the municipality who is responsible for the financial well-being, together with other officials of the municipality. And I've set out his duty, a summary of the case in respect of him in my heads of argument from paragraph 83 to 88. One of the duties of the fifth respondent is to provide an oversight function for the supply chain management unit and for procurement. So the argument that he wasn't told about the perceived irregularities by Kunana only applies to what happened after the transaction had been approved. One must also look at his conduct in respect of the approval process. And Your Lordship's been referred to the email. There's the quite broad email from Jenna, which is addressed to Mr. Boyson. He doesn't ask any questions when he gets that email. He doesn't ask why Jenna, who's not part of the supply chain management unit, is involved in seeking approval for this quote. He doesn't ask what attempts have been made to obtain other quotes. He simply says, I'm in agreement with the author and recommend that we purchase as per the quotation. That is not a qualified approval. He then says, and complete a deviation as per our supply chain policy, read with Treasury Circular 100. And the Treasury Circular 100 is important as well. He knows what the requirements are. He knows that there's a circular from government that says, if you want to purchase these things, you must go to the following suppliers, failing which you must provide an explanation. He doesn't look at that. He simply says, oh, well, we need masks. I know this because Mr. Phillips was looking for masks earlier, and I recommend that we purchase in respect of a single quote. And bear in mind that this quotation, there was only the Duneco quotation attached to this email. Notwithstanding what first and second respondents say, that is quite clear from the wording of the email. It's also admitted by Boyson in his answering affidavit. There was only that one quote. There were no ancillary documents, as are usually required or requested when one tenders, such as the declaration of interest, your CSD registration, your tax compliance certificate. It was simply a quote. My submission is that he was remiss in simply accepting that quote without looking into the process further. As I previously stated, he was holding a serious position in the municipality. He was paid a lot of money to do his job properly. And by failing to question this process, he was negligent. It may be that he wasn't told by Konana about the reservations with regard to this process, and that Konana requested payment authority from him. But the fact of the matter is that before he can approve payment, he must have insight into certain documentation. And there's a good reason for the process. One must have all the documents before you to make sure that there are no irregularities. He admits in his affidavit that, or he admitted to the SIU, that he wasn't sent all of the documentation that was required in order to approve the payment of this transaction. Nonetheless, he signed off on it. And my submission would be that in doing so, he acted negligently. He should, if he wasn't given all of the documentation, again, he should have asked for it. It's not good enough to say, I relied on my subordinates to do my job. His job requires him to apply his mind to a situation, not merely to rubber stamp a transaction carried out by his underlings. And it's correct that the SIU cannot point, there are no facts that point squarely at collusion between the fifth respondent and the other respondents. But the fact of the matter is that he was grossly negligent in carrying out his duty. And that the SIU would then be, or the municipality, would be entitled to seek compensation from him in terms of Section 32 of the MFMA. My Lord, while we're on the issue of Mr. Boyson's evidence, he's quite clear, and in his evidence, well, firstly, he agrees that the transaction was irregular, and he is quite clear that the deviation, the quote that was sent was a single quote attached to the email, that there were no other quotes attached to that email, and that the other quotes were only attached to the request for deviation that was submitted the following week. So the argument by the first and second respondent that this was not a single quote that was considered in isolation when the decision was made to accept it is not true. It's not correct. My Lord, with regard to the first and second respondents, two factual issues or statements I wanted to make. To just as a matter of interest, the total population of Matsukama municipality is apparently 67,000 people,
Yes,
most of whom are residents.
I've also looked at it 5 o'clock this morning.
So
But
most of those
that was in 2011, according
that's in
to
2011. The issue of the bank details, when the bank details of Mr. Hendricks's wife was requested or given, that can be found. Where am I? That request was made on the 6th of March 2020. And that's
I've got it.
yes.
And then you'll find that in one of those annexures.
It is in the annexure. It is in annexure AKR, I believe AKR 4. It's at page 780. AKR 3.
Yeah, that is, we were talking of Aldridge Green Eyes.
That's right. And they ask Mr. Claassen to look at his records on the 6th of March 2020, and that's where Mr. Hendricks sent him a message which contained his wife's bank details.
Yes, no, I've got that. Yeah.
So that was shortly before this incident. The confusion perhaps with 2019 is that Mr. Hendricks, who admits that these are his wife's bank details, says that this payment was made in respect of a transaction or business dealings in 2019. But he's very vague. He doesn't say who the business dealings were. He doesn't specifically say business dealings between Mr. Claassen and his wife. He just says business dealings. So I would submit that they're probably business dealings with himself. Okay, sorry, I'm just paging through my notes. The statement was made on behalf of first and second respondent that there wasn't much of a dispute raised, or there weren't that many facts in dispute, and Plascon evidence applies, and the court cannot find that the version of first and second respondent and Jenna is so far-fetched as to be rejected. I would disagree entirely. The evidence with regard to the relationship between second respondent and third respondent, which is denied by them, I would submit that the denial is so implausible, given the fact that they were close enough to phone one another in the evening and to either lend or give one another money. I would submit that that denial is so implausible it should be rejected. Similarly, the denial that second respondent's conduct in phoning third respondent and fourth respondent to offer or inquire about PPE is not an unsolicited bid. It is quite clearly an unsolicited bid as defined in the SCM policy. So their averments in this regard must be rejected as being wholly implausible. Similarly, Jenna's denial that, or his averments that the declaration was attached to the original emails on the 3rd of April, that's also not plausible. It's clear from the email itself and from Boyson's evidence that there were no other documents attached to that email. It was only the quote.
Just refresh my memory, was he referring to the declaration of interest?
No, the deviation, I beg your pardon.
Oh, yeah, you mean the deviation, yes.
The deviation,
yes.
yes.
Yeah, well, that was later, yeah.
Yeah. The argument was made later that the deviation, because the deviation itself has not been attacked, it stands, and then the court cannot set aside this transaction. My lord, I would agree that with the court that is too narrow an interpretation of how the law works. It's implicit when the applicant asks for the decision to be set aside. It's implicit that the deviation should also be set aside. To the extent that it's necessary, we know that the deviation request was only approved after the decision was made. There would seem to be an argument that the court must look at the context and the circumstances in place at the time that the deviation was approved, and the urgency of the decision-making process, so that it was okay for the decision to be made on the Friday before the deviation was filed. My lord, it doesn't follow. The approval decision was made at around about 6 o'clock on Friday evening. It could not have been given effect to until the Monday. So what was the rush? The deviation could have been filed with the quote and on the Monday morning and could have been dealt with then. The fact that the deviation was only filed after the fact points squarely to the fact that it was window dressing and wasn't actually part of this decision process.
I'm just wondering, I haven't thought about it, but if a decision is made and the responsible party, the municipality or the province or whoever, would then acknowledge some days or whatever after that, well, listen, we couldn't have done this without a deviation. Can you not ratify or deviate then and ratify the decision that you've made? I'm just maybe that's not very important bear in mind how you argue the matter, but I'm just considering.
Judge, I would think, well, firstly, the fact that a deviation is required would suggest that it's something that should be done beforehand. But more importantly, the deviation forms its basis, it's the justification for the decision to depart from the ordinary protocols.
Yeah.
So it must be something. So
yeah, you cannot do it later on as an afterthought.
No, and you can't do it later on. And even if you were able to do it later on, this decision was made by Hendricks. He doesn't give any explanation for the decision and for the fact that the deviation was done after the fact. He simply says he had had discussions with unidentified people that week, and on the basis of that, he made the decision. That is not sufficient. For the deviation to be valid, it's got to be made for rational reasons. Which brings me to another point. My learned colleague argues that we have sought to introduce the argument of rationality and that we're not entitled to do so because the notice of motion doesn't provide, or it doesn't ask for the review or for the decision to be set aside because it's irrational. My Lord, the concept of legality has expanded a lot over the last 20 years, and the grounds for review in terms of legality have also been expanded. Rationality is one of those grounds. But in any event, I would submit that I had dealt with this. The applicants aren't trying to introduce a new ground of review. What they've said is that the decision must be a rational decision. In the ordinary grammatical meaning of rational, it's a decision that must be made after consideration of factors which would motivate the decision. And this is part of the inquiry that has to be made by the decision maker in order to make the decision lawful. If the decision is made for without reason, then it becomes arbitrary. It is not a rational decision. And if it's arbitrary, it's unlawful. My Lord, with regard to the second requirement of Clause 26 of the procurement policy, there is a requirement that a report must be made to Council, setting out the reasons for the deviation. And no such report was ever made to the Council by Hendricks. In the replying affidavit, and I can't refer your Lordship to the exact paragraph right now, but the averment is made that the Council meeting is in fact resumed in June 2020. Some of them were virtual and thereafter they were held in person. And in fact, the third respondent resigned in a Council meeting in January 2021.
Yeah, that's why I say the first council meeting wasn't in August 2021.
No.
It's definitely already in somewhere in June, July, August 2020.
Yes, they resumed their business in, I've got June, it could be July, but I seem to recall the 28th of June, 2020. Yeah.
But he resigned at a council meeting in January 2021, meaning that there was already then a meeting held.
Yes, it was during the course of a council meeting.
Yeah.
While they were sitting.
Yeah, that's my memory also.
My Lord, the SIU is attacked for on the basis that their application is based entirely on hearsay evidence, and that the attachment of affidavits from Farmer and Kunana is not sufficient to transform the hearsay evidence into acceptable or admissible evidence. My Lord, I would submit that this argument favours form over substance. The affidavits of Kunana and Farmer and Wilbur Skippers and Sauls and Pastor Dean, in fact, these are affidavits. They don't become valueless because they haven't been transcribed and deposed to. This is evidence that was taken under oath. It is not correct to say that they cannot be considered and that the applicant's case is based entirely on hearsay evidence.
But they were dealt with.
They were dealt with. I've raised several issues with the evidence of Mr. Jenner. My submission with regard to his evidence is that his evidence on the whole is so implausible, it must be rejected. He's implicated in this transaction. With regard to and that goes to the issue again of delivery and the storage of the goods. My Lord, the municipality has a supply chain policy in place, which was agreed to in 2019. In terms of that policy, there's provision that there must be a logistics store. And it makes sense, because how would you know when you're running low on stock and when you have to order stock if it's not all kept in one place with a record? And that's one of the big problems that we have in this case, that there was no records kept of how much stock was received from Duneco. There were no delivery receipts in place at the time. On Jenner's version, he kept the stock at a sports center and handed it out on an ad hoc basis to various people. This is a severe breach of the SCM policy, and I would submit that it's not true. There was an argument made that somehow the directive from the national government in terms of the disaster regulation or disaster management act should not apply here or be considered because it wasn't referred to in the founding affidavit. My Lord, this is a question of law. These are regulations issued in terms of a statute. They don't have to be included in the founding affidavit. The court can take cognizance of the law in place at the time. That directive overruled the requirements of Section 168 of the MFMA, which means that the Circular 100 was very much in effect at the time. And it's clear from the documentation, the request for deviation and the preceding emails, that the municipal officials regarded it as binding on themselves in the first place, and secondly, paid lip service to the requirements of the circular. Because that circular also required, it said if they were to source goods from any source that was not listed in Annexure A, they would have to report to the Treasury. They would have to confirm that the goods supplied were of the same standard as required by the Department of Health, and that they would cost the same amount or were cheaper than the goods in Annexure A. And this wasn't done either.
Well, if you say the same standard, obviously you can't expect an official to consider whether it's the same standard, but what you normally get is you get a certificate from the supplier to say
yes,
there was compliance with ISO so-and-so, whatever it is.
That's correct. And my Lord, the point was made in the founding affidavit that there couldn't have been, nobody knew whether the masks and gloves quoted on by the first respondent met with those specifications, because those specifications were only sent to him on or about the 8th of April. So how then could the municipal officials have signed off on the deviation saying that there was compliance with Circular 100? My Lord, it seemed to be argued that the court couldn't set aside this transaction as being irregular if there was no proof of corruption. That is not the case. If the transaction was unlawful for want of compliance with the supply chain management policies or with Circular MFMA 100, then it is irregular and it should be set aside. The corruption is a different question. My lord, you referred to, my colleague referred you to the very recent judgment of SIU versus Pumila Property Investments. I haven't had time to read the judgment in full, but paragraph 16 to 18 don't make any, or they don't take issue with paragraph 42 of the Central Energy Fund decision, which states that, well, for the want of a better word, the guilty tenderer, the non-innocent tenderer.
Oh, I also understood it like that, yeah.
Is entitled to restitution. My lord, I believe I've covered all the points, unless there's something else that you want me to address you on.
Was just considering, even if I find that the contract was unlawfully entered into, it should be set aside. But what about the consequences? Shall we not leave it like that? I mean, on the basis of all pay, say, well, you know, it's water underneath the bridge.
But the all pay judgment was different in that it had to do with the provision of ongoing services.
Yes, I know, but in this case, it's finalized. It's
finalized, but then you would be allowing the setting aside would really have no effect, and you would be allowing an illegal transaction to stand. And that would not, it cannot be, particularly in circumstances where there appears to have been moral turpitude. Because just in terms of the law of contract, if an illegal contract, neither party should benefit, and if it's an enrichment claim, the court has to look at the question of moral turpitude. I would submit in this instance, there is most definitely evidence of moral turpitude. And again, I refer the court to the Prasa versus Swifambo judgment, where the court says an innocent party is somebody who's not implicated in any manner with the irregularities. And in this instance, the first and second respondents are implicated in the irregularities. There was an unsolicited bid. There was an unacceptably close relationship between second respondent and third respondent. There was an attempt to deceive the municipality by lying on the bid declaration document.
Is that your argument?
That is my argument, my lord.
Thank you. I see that your colleague is raising his hand there. You want a second bite at the cherry, or do you want to go to the toilet?
No, my lord. I think it just certain things which I need to clarify, which appears to be not factually correct. If one have regard to the affidavit of Boyson at paragraph 88.
Yeah.
There, with reference to the affidavit of Kunene, the allegation is incorrect. Kunene confirmed in his affidavit dated 5 April 2022 that he reported the transaction in or during August 2020. In other words, there was a report of the transaction to the council in 2020. So it's not correct to Kunene, who is the applicants are relying on Kunene.
Yeah.
So he reported that to the municipality, to the council.
You say Boyson is incorrect.
No. I say that the applicants are incorrect because they say the transaction was never reported. Right. And I'm just stating what is on the affidavit, that the affidavit confirmed that the transaction was reported.
Okay, but let us just for my notes that can I just go to Boyson's affidavit to make sure that we understand each other.
Yes.
Where is Boyson now again?
Boyson, well, the court will find Boyson under volume 5. Is it Now, volume 5, it looks at, it's at page 20 there, but it's the particular paragraph is paragraph 88. That's in line with the case law. Even if I don't argue on behalf of Boyson, I just need to put the facts corrected. It's in line of the case which I referred the court earlier, the motor tax matter. It relates to regulation 36.2.
Yes, thank you. I've made my words.
Okay, and just the last point, my lord, it's the important part of that case I've quoted. It's paragraph 18.
The SIU case.
Yeah, the SIU case, the SEA case, it's paragraph 18. That's the case which deal with what the approach should be in those circumstances.
Yeah, the 2023 judgment of 3 April.
Yeah, that's
I'll have a look at that as well. Yeah.
No, some submissions follow.
Thank you.
Thanks.
Lady and gentlemen, thank you very much for the manner in which you've dealt with this as swiftly as you've done. I'm glad that we could have dealt with it. We're waiting for the argument of the third respondent, which I've given time to file by Friday.
Yes.
I'll try my best to give a judgment as soon as possible thereafter. It will probably be by the end of the week thereafter, by the 28th or so of April. I'll use that long weekend to deal with it, and maybe I can give it on that the weekend, the Tuesday after the long weekend. But in the circumstances, I reserve my judgment, and I'm so sure that you're satisfied that I can send it electronically to all the people that we've sent the previous notices to.
Yes.
All in agreement. Yes. Thank you
All
for cooperation. I appreciate. We will then leave the meeting at this stage.
Thank you,
Thank you, Judge.
Thank you.